Access to the bill. Let's recognize
He's on the beach.
Is supporting one organization over another.
Senate will please come to order. Is there something going on with one of the cameras? We have a slight technical. Well, they'll fix it hopefully, but your camera was making a lot of noise. That's okay, but that's why we unplugged it. Good luck figuring that out. So the Senate will please come to order. Thank you. Today's devotional exercises will be conducted by Reverend Corinne Eskridge of Weybridge Congregational Church. Welcome.
Good afternoon.
Afternoon.
I bring you all greetings from the Weybridge Congregational Church in Addison County. And I want to begin by thanking Senator Hardy for inviting me to be here. It is a real honor and pleasure to be with you all. So as I know you all are busy people who probably came here from one meeting and have several more later today, I invite you to take a moment for centering. I invite you to take a deep breath in and release it. And in the next few moments of silence, feel your feet on the ground, your back on your seat. And now join me in an attitude of prayer. Holy One, God whom we know by many names, Spirit in whom we all live and move and have our being. I pray with deep gratitude for the calling you have given to these lawmakers and their staff to serve their neighbors in our small and mighty state. Grant them wisdom and clarity. May they listen to the concerns of their constituents and of one another with open hearts. May they be moved to courageous action by the compassion that is the gift of our shared humanity. May they do justice, keeping in mind the most vulnerable of our neighbors. Empower the work of this body to bring more love, more justice, more connection, more dignity, more life to all Vermonters. Spirit who unites all of us and all beings, be present here with all of these gathered and with all of those they represent. May it be so. Amen.
Are there any announcements? Seeing none, we do have a couple of House bills for reference. The first being H-132, which passed the House on February 23rd. Please listen to the first reading of the bill.
H-132, an act relating to prohibiting discrimination against persons without homes.
Now you've heard the first reading of the bill is referred to the Committee on Economic Development, Housing, and General Affairs. We have H-745, which passed the House on February 23rd. Please listen to the first reading of the bill.
H-745, an act relating to the Vermont Parentage Act.
Now you've heard the first reading of the bill is referred to the Committee on Judiciary. We have H-861, which also passed the House on February 23rd. Please listen to the first reading of the bill.
H-861, an act relating to reimbursement parity for healthcare services delivered in person, by telemedicine, and by audio-only telephone.
Now you've heard the first reading of the bill is referred to the Committee on Finance. That brings us to the orders of the day. Our first order, Senator from Chittenden Central.
Thank you, Mr. President. As senators will see, Proposition 1 is up for action today. I regret to report that that action will constitute a motion to move Proposition 1 back to the Committee on government operations. Before I make that motion, I'd like to just say a couple of things. First of all, I think all of us are aware that our sheriffs and other county officials, including state's attorneys, have serious allegations, some of them pending against them. Very serious allegations in some cases. But among other things, living out of state, but cashing a Vermont paycheck, allegations of assault and other related activities. So it was the Government Operations Committee's charge to deal with this situation. And I want to say that they did a stellar job. And my reason for saying that is that they determined after long research that the only avenue to pursuing any kind of redress to these constitutionally protected sheriffs was to change the Constitution, to amend it. They came forward with Proposition 1, which would put a number of county offices, including sheriffs, into the exact same situation where probate judges now sit in the Constitution. I thought it was an efficient response. It was timely in that we had plenty of time in this biennium to move it to the House, to move it eventually on to the voters. It turned out after some weeks of conversation with the Senate that the will was not here in the Senate to advance Proposition 1 to the House. I am sorry about that, and I regard that in some sense as a personal failure, and I own that. But I want people to understand that none of that failure attaches to the Government Operations Committee or the Senate Judiciary Committee, both of which did lots of research and I think were dedicated to finding a solution to a horrible problem that exists in part because of a piece of our Constitution that shields public officials for a period of 4 years from voter scrutiny or from being removed from office, other than through a completely onerous impeachment procedure. So with that said, Mr. President, I will say that this rules out nothing in the future in terms of addressing this, but it will add years to our ability to address this problem. And again, I think that's a shame. So with that said, Mr. President, I would move that Proposition 1 be recommitted to the Committee on Government Operations, and happy to answer any questions that people might have.
Now, the senator from Chittenden Central has moved that the Senate recommit Proposition 1 to the Committee on Government Operations. Are you ready for the question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you have recommitted Proposition 1 to the Committee on Government Operations. We now have up for consideration S209. 209 was read for the first time and was referred to the Committee on Judiciary, which considered the same and recommends that when amended, the bill ought to pass. Please listen to the second reading of the bill.
S209, an act relating to prohibiting unserialized firearms and unserialized firearms frames and receivers, and to juvenile offenses in the criminal division.
Now you've heard the second reading of the bill. For the report from the Committee on Judiciary, the senator from Chittenden Central.
Thank you, Mr. President. As you just heard, we will be taking up S209, which you will see under the short title is known as the Vermont Ghost Guns Act, should it be passed. And before I describe what a ghost gun is and what the bill purports to do about them, I want to just take us back, if I could, almost exactly 6 years into the past. That is February of 2018 was the Parkland, Florida massacre, if you remember that. It stunned a nation even grown horribly accustomed to these sorts of tragedies. But just days after Parkland, in Vermont, we had a near shooting. So Jack Sawyer from Fairhaven Union High School, a former student there, had apparently planned for 2 years to commit a school shooting. And among other things, once he was turned in by an informant who courageously stopped this, authorities found what he titled a diary of an active shooter. And they recovered his texts to various people, one of which called the Parkland shooting natural selection taken up a notch. So this was the sort of tragedy that had happened in Florida. It was the sort of tragedy that has recently happened in Lewiston, Maine, and far too many communities around America. The difference between their shootings and our near shootings is that we had a second chance. We had the ability to do more, to act quickly, to prevent a shooting, having avoided one very narrowly. And so back in 2018, we passed S55. The governor signed it on the steps of the State House. The centerpiece of that legislation was universal background checks. And what we meant by universal background checks was that we were, in addition to the normal background check regime, we were adding the sale of used weapons. So if you go back to 2017, you could communicate over the internet with someone, arrange to buy a weapon, give them, let's say, $500, and drive away with a semi-automatic weapon. What I just described was what Paul Heinz, a reporter for Then 7 Days, actually did. And he wrote that up. And as partly in response to that, we passed universal background checks. Now, I wish I could say that they truly were universal, but they weren't, because we had the gun show loophole, which we closed. We had the Charleston loophole, which said that if you put in for a background check and 3 days elapsed, you could get the weapon without the background check. So we changed that. We narrowed the Charleston loophole to 10 days, 10 calendar days, and that's where we now are. So we had done a great job building out and strengthening the background check system following the Fairhaven incident. But the work is not done, and today's bill continues that same build out of background checks, making sure that people who are prohibited from having guns cannot get a gun without a background check. The loophole that we're talking about today is produced by technology. In other words, you can buy a 3D printer now, take it home and produce a gun in your basement that evades the entire background check system. You can also, over the internet, buy a kit called a buy, build, shoot kit, which is all the pieces of a weapon, and you can bring it down into your basement, screw in a couple of things, make a couple of adjustments, and you have a fully functional weapon. That also does not necessarily go through the background check system. So those are referred to as ghost guns, those two kinds of weapons that can be produced and evade the background check system. So it was the intention of the Judiciary Committee to close that loophole, to make sure that everyone who gets a gun in Vermont moves through the background system. And just to remind people, when we talk about prohibited persons, you are prohibited for extreme offenses, for violent crimes, which I have a list of here if anybody's curious, but if I read it to you, you would understand why those folks should not have guns. So with that said, I will direct senators to page 434 of today's calendar. I want to say at the outset that the touch here is relatively light, in my opinion. It does not prohibit somebody from producing a gun in their basement. It does not prohibit somebody from ordering a kit over the internet and assembling it in their basement. But what it says is if you produce a weapon, you need to get it serialized, because it would have no serial number on it. And having gotten a serial number, you then need to complete a background check in order to legally possess and use that weapon. So senators will see that under the definitions, there are, among the other definitions, fire control component, some pieces of the gun that would need to be fixed to the frame or receiver of the firearm. There's a definition for frame or receiver, and there's also a definition for unfinished frame or receiver. Let me just concentrate on the unfinished frame or receiver part. So if you buy a kit, you're buying something that cannot function as a weapon until you put it together. So you'll notice there that it says a machine, a casting, printing, etc., that has reached a stage in manufacture where it may be readily be completed, assembled, or converted to be used as the frame or receiver of a functional firearm. Now, that language is not new. I referred us back to 2015. Since 2015, we have used that standard of frame or receiver of any such weapon that may readily be converted to use. So a number of the laws that we've passed since 2015 already use this standard of an unfinished frame or receiver that's near usable being classed as a gun, as a firearm. So with that said, on 435, you'll see unlawful conduct involving unserialized firearms, frames, and receivers. So there are three prohibitions here. The first is A1, a person shall not knowingly possess, transfer, or offer to transfer an unfinished frame or receiver. That is, again, one that's very, very nearly complete and ready to operate, unless the unfinished frame or receiver has been imprinted with a serial number by an FFL, a federal firearms licensee, pursuant to federal law. Then there are a series of carve-outs for if that person is acting within the scope of the licensee's license, temporary possession to get it to the FFL. So if you're driving there to have it serialized and you got stopped, you would be carved out by this. And an unfinished frame or receiver transferred to or possessed by a law enforcement officer for legitimate purposes. So when law enforcement officers confiscate these guns, they have possession of them and they may need to transfer them for official reasons. Flipping the page is the second prohibition, B1. A person shall not knowingly possess, transfer, or offer to transfer a firearm or frame or receiver not imprinted. B1 and C1 are essentially talking about, or I'm sorry, A1 and B1 are talking about an unfinished or a finished receiver or frame. The same prohibition applies if they are not fixed with a serial number and there's been no backmatch. So you'll see under B1, the prohibition, there is again a series of carve-outs. It's a more elaborate carve-out because under D, E, and F, you'll notice that antiques are basically always carved out in our gun laws. So if you are a collector, you're not going to be affected by this. A firearm that has been rendered permanently inoperable would not be triggered. And the other is a firearm that was manufactured before 1968. 1968 is when federal law required serialized numbers on guns. So if something is pre-1968, it is not captured by this legislation. Then C1 is the prohibition on 3D printing. But it's not a prohibition on printing it. It's printing it without a serial number and then not going to get a serial number. So a person shall not manufacture a firearm or frame or receiver of a firearm, including by a three-dimensional printer that is not imprinted with a serial number by a federal firearms licensee, etc. So again, nothing here says you can't print a gun. Nothing here says you can't, as a hobby, create a gun. You can certainly do that. But once it reaches the operable or near operable stage, you need to imprint it with a serial number, at which time a background check is performed. You'll see under there the offenses and what the penalties are. These are 2 misdemeanors, and then for a third offense, a felony. And then the one that I would point out at the bottom is on 436 down near the bottom, subsection 2, a person who uses an unserialized firearm while committing a violent crime, and again, that's that list of violent crimes, shall be imprisoned for not more than 5 years or fined not more than $5,000. That is a felony, and it turns on the word use. So use means that it's actively used in committing a crime, including brandishing the weapon as a threat to get compliance. The next section, 4084, Federal Firearms Licensee's authority to serialize. I want to make sure everybody sees the word may in that first line. A federal firearms licensee may imprint the serial number on an unserialized firearm. This does not compel FFLs to serialize guns. It says that they may do it. And in fact, now FFLs have different levels of gunsmithing that they do. So some will choose to do this, some won't. But we understand from our testimony that the process is not overly complex. It's done by laser generally, and it can be done in a few minutes. What they tend to do with plastic guns is affix through certain means a metal plate into the, either in the manufacture of that plastic gun, or it can be applied afterwards. And the metal plate is then engraved with the serial number. So that's the serial number, but I do want to stress that whenever one of these weapons is taken, imprinted with a serial number, before it's given back, there is a background check. And so that's where we're going next. You'll see on page 437 in those longer paragraphs that this is the procedure if an FFL decides that they want to be in the business of serializing firearms. It gives some procedure for them to follow. It also says that returning under 3C, returning a firearm, frame, or receiver to a person after it has been serialized pursuant to federal law or this section constitutes a transfer that requires a background check of the transferee. That is the heart of what this bill is doing. It's bringing these guns, printed or assembled, out of sight of the background check. It brings them back into that system through the FFL. The other thing I want to point out just above that, subsection 3, a licensee shall not be deemed a firearms manufacturer solely for serializing a firearm frame or receiver pursuant to this section. We had testimony from Perro's Gun Shop. This was one of his concerns, that by serializing a gun, he might be considered the manufacturer and therefore liable in some unstated way. So we added this at his urging, and I think it makes the bill stronger. You'll see that at the bottom of 3C on 437, there is a background check conducted. And if that person fails the background check, you'll see towards the bottom there, in that event, the licensee, the dealer, shall deliver the firearm, frame, or receiver to a law enforcement agency for disposition. So if they fail the background check, they do not get the weapon back. It goes to a local law enforcement agency, and instead the owner of the firearm is given a receipt saying that it was taken for that reason on letterhead, and it allows the transfer to remain. It isn't completed, but the person has a record of what happened to their weapon. And you'll see a licensee, a federal firearms licensee who violates subsection B or C. For the first offense, it is a fine-only misdemeanor, and that's on purpose. There's no jail time. Fine-only misdemeanor for running afoul of this as a dealer. But for a second or subsequent offense, be imprisoned not more than 1 year or fined not more than $2,500. So still a misdemeanor for a dealer who twice violates that law. That was on purpose. We didn't want to, if we could all avoid it, we didn't want to be criminalizing FFLs even for this kind of conduct. So we've tried our best to make those penalties lighter than would be applying to the people who would be producing the gun and not getting the serial number. The last thing that I will say, Mr. President, is the effective date is December 31st, 2024. That's deliberately pushed out a bit from when the bill might be signed or come into law. And the idea is to give people with unserialized weapons in their possession a chance to get them serialized. So it is not the intent of this legislation to criminalize people. The intent is to stop the flow of unserialized, untraceable weapons that are being put out without a background check. So we've tried to make it a light touch on dealers, a light touch on people who might want to engage in this kind of personal manufacture. But at the end of the day, what we're concerned with is that we never have a Parkland shooting, never have a completed Fairhaven shooting in Vermont. And I think we have been fortunate to this day, following the 2018 near miss in Fairhaven, that we have passed a number of laws to build out the background check system. This is not to affect hunters, not to affect target shooters, not to affect people who want a gun for their own self-defense. It is simply to prevent people from evading a basic, sensible background check procedure. So with that said, Mr. President, I'm happy to answer questions. Our voting committee was 4-1-0, and I do have a witness list should people be interested. Thank you.
Just state the question, then I will call on folks in a second. The question that you will be discussing is, shall the Senate adopt the report of the Committee on Judiciary? Are you ready for the question, Senator from Bennington?
President, I thank the senator from Chittenden Central, I guess, for his report. And I think it's important to note that this is the first of 3 different bills dealing with public safety that you're going to see, hopefully, from the Judiciary Committee this year. The other ones have to do with drugs, apartments being taken over by drug dealers, and violations of conditions of release. This bill first spent a lot of time with my local law enforcement. I do that every fall and try to get a sense of what's going on. I also have access to a few former criminals who I spend time chatting with about what's going on in the streets. And what appears to be happening, at least in Bennington County, particularly in Pownell, Bennington, Dorset, and for some reason Rutland, is a growth in these so-called ghost guns. Why? I think our FFLs, or federally licensed firearm dealers, are doing a terrific job of stopping straw purchases. So people have found other ways to get around it. And this is one of those, and that's part of the genesis for this bill, quite frankly. It's based upon Washington law that's been passed there. And I think it's a good bill that I hope will get support from the Senate. But I do want to mention that in one of those visits, the other senator from Bennington District and I went to visit our sheriff. And we got talking about various criminal activity. And I mentioned ghost guns. And he said, oh, I got a couple. And goes right into the evidence locker and brings out a couple of ghost guns. That was shocking to me because they were made in somebody's basement by teenagers in Dorset, Vermont, of all places to be building ghost guns. One wouldn't think of Dorset as being a source city. And yet these teenagers were able to do this. God, I have trouble getting my own printer to print out bills and messages that I want to print out, let alone a ghost gun. But these teenagers were adept at doing that. They obviously weren't allowed to possess a firearm, but there it was, and they had built it. That convinced me that this was an important piece of legislation. And I've gotten a lot of emails against the bill. I'm sure you all have, but that's the motivation. And I thought the senator from Chittenden did a great job of explaining the background check and the importance of it. I recognize a background check is a pain. Got to go back 72 hours later to get your firearm, blah, blah, blah. But it does protect us from those who shouldn't possess. And that's really the goal of the bill. So thank you, Mr. President, and I hope we'll get a strong vote.
Senator from Rutland.
May I inquire the reporter?
The senator from Chittenden Central is interrogated as the reporter of the bill.
Thank you, Mr. President. So excellent job explaining it. Does this bill require a legally manufactured, ATF approved, privately manufactured firearm by a law-abiding citizen that currently owns one right now? Does it require them to serialize that firearm?
Yes.
It does. Okay, thank you. Thank you, Mr. President.
Question is, shall the Senate adopt the report of the Committee on Judiciary? Are you ready for the question? Senator from Washington.
Mr. President,
Senator from Chittenden Central is interrogated as a reporter.
Thank you. I just had a question about the word temporary possession, if that's defined. I didn't see it in here, just so the Senator from Bennington mentioned emails, and so I wanted to make sure I had this correct. When it says that it shall not apply to temporary possession, both in A1 and B1, I wondered if that was defined somewhere else. I didn't see it.
It is not defined in the bill. I believe what we're talking about is a standard that would be determined in the event that somebody challenged whether it was temporary possession. It would be adjudicated by a judge, a court of law. But I think of that carve out, this is the top of 446, temporary possession or transfer of a firearm, blah, 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 for the purpose of having it imprinted. So the for the purpose part qualifies the temporary part. So having it in your car for a week, saying, well, you mean someday to take it, to get it serialized would not count. But if you are in the process of taking it to be serialized, that would count. You can also, under the provisions of this bill, give the weapon to someone else as a temporary transfer to have them take it to be serialized. But again, it's at the end of the day, if it had to be adjudicated, it would be a judge determining whether that constituted temporary possession.
Okay, thank you. And one other question is similar. We do not have that temporary exemption under C1, and I just wondered why that's not the case for what, for a 3D printed ghost gun.
Well,
Because they can't print them with the serial number, right? They have to, similar to the other
Right.
guns, they have to take it somewhere to get serialized. So I assume the same thing would apply if they printed it, if they were driving it
yeah,
to get it serialized, that would also.
I think it's a fair point that we're not meaning any difference of the two. I'd be happy to think about whether an amendment at third reading might bring it in line with the language from the previous two.
I have no opinion. I thought maybe I was missing something. That was on my own.
No, I think it's fair to say that they're different in that the temporary part of it does allow somebody a certain dispensation if they're in the act or near the act of getting it serialized. So I could see language in C1 that would add an additional element there.
Thank you, Mr. President.
Senator from Caledonia,
Thank you, Mr. President. May I inquire the report?
Senator from Chittenden
I'd
Central is
like to-
interrogated.
I'll go back to C1. It's just the sequencing. It seems like you can't imprint before you've manufactured.
Mhm.
And that's why I'm wondering the sequence. It's not necessarily the temporary. It's, it seems like it says you shall not manufacture that is not imprinted. And I don't know how you would imprint before you've manufactured. It may just be the sequence, but it was just the wording raised a question. And perhaps that is, you can clarify it, or maybe I'm reading it incorrectly.
No, I think, Mr. President, it's connected to the previous question. So I will do it this way. I'll ask the Chair of Judiciary to have the committee think about an amendment for third reading where we might satisfy both of those questions. I think it would, left to a judge, it would probably not be a problem, but it's better to work it out in clear language.
Thank you.
Thank you.
Senator from Windsor,
Thank you. Mr. President, may I inquire the reporter of the bill?
Senator from Chittenden Central is interrogated.
Thank you. I support this bill. We have put in a bill to not allow 3D printing of guns altogether, but I'm happy with what we're doing and moving forward with here. I'm just curious, what is the scale of the challenge we face with 3D printed guns? What, if you could just give us a picture of the landscape of the number. I know we have the chair of the committee reference his experience in learning about how prevalent it was in his area, but I'm just curious if we have a picture of the scale of the problem.
Sure. It is growing, and I think it's growing here as well as in other communities, but there are 13 states that currently have legislation prohibiting unserialized ghost guns without background checks. And those are Maryland and California, 2 of those 13. Those 2 decisions or laws have been challenged in court, and they have received differing decisions from district courts. So the one in Maryland was struck down under the Bruin decision. And the thinking there, if you're familiar with Bruin, you know that it requires that there be an analog historically. And so unserialized plastic guns have no historical analog. So there was no prohibition on having unserialized weapons. And so in Maryland, it was struck down. The California law was upheld. And the thinking was that it was part and parcel of the background check system. So this is an expanding problem with some legal murkiness out there. But it seems to me very much on all fours with all of the background legislation we've passed. So it seems to me that if a court were to say that serial numbers themselves are unconstitutional, they would also have to say under this legislation that background checks are unconstitutional. And if we wind up in that world, then we're in a real world of hurt. But I would say that this problem of ghost guns is in Vermont, it is visible as a problem, but in states like New York, Massachusetts, California, it is becoming a huge problem.
Senator from Essex.
Thank you, Mr. President. I think it's very important to state that the laws that prevented Fairhaven from ever happening worked. That's what they did. The laws that we have in place worked. In fact, from what we understand, the person who created all the mess wasn't charged with a crime. You know, I do have people that are around me that don't like firearms. Their comment to me was boy, that was awful easy, and we can't wait to do some more. And I think this is one of those bills that is seeking something that isn't a problem in our state and creating a law to pretend that it is. Thank you, Mr. President.
Question is, shall the Senate adopt the report of the Committee on Judiciary? Senator from Chittenden North. Senator from Chittenden Central is interrogated.
Going back to the question of whether C1 needs an addition. I believe B1 does indeed capture, if you have printed a 3D weapon, you shall not knowingly possess, transfer, or offer to transfer it, because it is now a firearm that is non-imprinted. So I believe that then those 6 subheadings do refer to any firearm, whether it's been printed or not printed. So that would just be my food for thought in case that's helpful.
I appreciate that, Mr. President. I'll commit to the body that we will discuss it again in judiciary and determine with the help of our Ledge Council what's the best way to either amend or not amend.
Thank you.
Thank you.
Question is, shall the bill be amended as offered by the Committee on Judiciary? Are you ready for the question? If so,
Roll call, please.
roll call has been requested. Senator from Chittenden Central. Question is, shall the bill be amended as offered by the Committee on Judiciary? Are you ready for the question? If so, the Secretary shall commence to call the roll.
Senator Baru,
Yes.
Senator Bray,
Yes.
Senator Brock,
No.
Senator Campion,
Yes.
Senator Chittenden,
Yes.
Senator Clarkson,
Yes.
Senator Collmore,
Yes.
Senator Cummings,
Yes.
Senator Dooley,
Yes.
Senator Hardy,
Yes.
Senator Harrison,
Yes.
Senator Hashim,
Yes.
Senator Ingle,
No.
Senator Lyons,
Yes.
Senator McDonald.
Yes.
Senator Mazza. Senator McCormack.
Yes.
Senator Norris.
No.
Senator Pershman.
Yes.
Senator Ron Hinsdale.
Yes.
Senator Sears.
Yes.
Senator Starr.
Yes.
Senator Bihowski.
Aye.
Senator Watson.
Yes.
Senator Weeks.
Yes.
Senator Westman.
Yes.
Senator White.
Yes.
Senator Williams.
Yes.
Senator Renner.
Yes.
Senator Mazza.
Please listen to the results of your vote. Those voting yea, 26, those voting nay, 3, and you have amended the bill as offered by the Committee on Judiciary. Question now is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay.
No.
The ayes appear to have it. The ayes do have it, and you've ordered third reading of S209. We now have up for consideration S199. S199 had third reading ordered. Are there any amendments before third reading? Seeing none, please listen to the third reading of the bill.
S199, an act relating to mergers and governance of communications union districts.
Now you've heard the third reading of the bill. The question is, shall the bill pass? Are you ready for that question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay.
Nay.
The ayes appear to have it. The ayes do have it, and you have passed S199. We have up for third reading S278. I apologize, I didn't read the title prior on the last bill. An act relating to contributory negligence in a civil action involving sexual assault. Are there any amendments before third reading? Seeing none, please listen to the third reading of the bill.
S278, an act relating to contributory negligence in a civil action involving sexual assault.
Now you've heard the third reading of the bill. The question is, shall the bill pass? Are you ready for that question? If so, all those in favor, please indicate by saying aye.
Aye.
Those opposed indicate by saying nay. The ayes have it, and you have passed S278. We now have up for consideration H516. Second, the bill was reviewed by the Committee on Government Operations and recommends that the bill ought to pass. Please listen to the second reading of the bill.
H516, an act relating to approval of amendments to the charter of the city of Essex Junction.
Now you've heard the second reading of the bill. For the report for the Committee on Government Operations, Senator from Chittenden Central, Senator Bihowski.
Thank you, Mr. President. H516 pertains to the Charter of Essex Junction, the city. Section 1 of the bill is standard charter language seen in most charter changes. Section 2 begins with substantive changes to the charter. In the first instance of change, the city repeals its existing conflict of interest policy, with 76% of the voters supporting this change. It also sets a new conflict of interest policy that continues to state that council members may not hold city employment unless required by state law. This change is being made after an instance occurred where under state law, a council member was to serve as the health officer in the instance when this office was vacant. But due to the previously restrictive charter language, this was not allowable under the city's charter. And it left the city without an acting health officer. This charter change rectifies that by allowing an exception to their conflict of interest policy if state law requires it. 86% of the voters supported this new language. The next change allows for the town's moderator to be an appointed rather than an elected position. The city is moving towards this due to the fact that they do not hold floor votes, but use Australian ballot, and other towns who use Australian ballots have done this as well. 78% of the voters supported this change. The last instance of change allows the city to set their annual meeting date yearly, provided that they do so on or before January 1st. This does mean that the annual meeting vote could change every year. It hasn't historically. The city is opting for this flexibility as they currently hold their annual meeting at the same time as the school budget vote in April. But should this date be changed to align with town meeting day, they would want the flexibility to align their vote accordingly. The city vote has historically been held not on town meeting day, so that when the city and the town were one municipality, the city residents were able to attend both their city annual meeting and the larger town's annual meeting. This article of change was supported by 86% of the voters voting. 25.6% of registered voters voted in the annual meeting on April 1st, 2023. The vote in the House was unanimous, and your Senate Government Operations Committee voted this charter out of committee on a vote of 6-0-0. We ask for the body's support. We did hear from Legislative Council, the sponsor in the House, and the city manager of Essex as to why these changes are being suggested. Thank you.
I've heard the report of the committee. The question is, shall the bill be read a third time? Are you ready for that question? If so, all those in favor, please indicate by saying aye. Aye. Those opposed indicate by saying nay. The ayes have it, and you've ordered third reading of H 516. We now have a joint resolution for action, JRS 47. The question is, shall the Senate adopt the resolution? Are you ready for the question? If so, all those in favor, please indicate by saying aye. Aye. Those opposed indicate by saying nay. The ayes have it, and you have ordered third reading, you have passed, adopted, all those words, JRS 47. Senator from Chittenden Central, do you have a motion?
Thank you, Mr. President. It was our intention to gavel out at this point to allow an explanation of the Budget Adjustment Conference Committee report, and then to gavel in when that was complete.
So are you moving for a brief recess?
Absolutely.
That's what I thought. The Senate will stand and I suppose I'll just take it as a prerogative of the chair. The Senate will stand in recess till the fall of the gavel.